This case is so insane. It's so insane. It's this case is crazy.
The taillight is item 3-1.
Oh, 3-1. I'm so sorry. Okay. With regard to that particular item, your lab has different departments, correct? Criminalists who do different things, correct?
Yes.
You are aware that there are scientists within your lab who do DNA analysis, for instance, correct?
Yes.
And with regard to the order of processing items, is the DNA analysis done before or after you get the item?
It's usually before.
Okay. In this case, it was before. Am I correct?
I believe so.
Were you made aware that there were 3 contributors of DNA to that taillight, 3-1?
How long? Were you made aware of that?
No.
Once you reconstructed the taillight, you'll agree with me that it was missing a piece, correct? Or pieces?
There was an empty spot on the overall reconstruction, yes.
Were you ever provided with any pieces of taillight that would have filled in that missing spot?
No.
Were you ever provided or told about any pieces recovered from One Meadows Ave in Canton?
No.
Were you ever told about a collision at One Meadows Ave in Canton?
There are really no words.
God save the Commonwealth of Massachusetts.
Welcome. This is the I Don't Belong Here show, and I am your host, Samantha Benigno. I am a behavioral scientist, a career psychotherapist, a 6th-year PhD candidate in clinical psychology, a master's level psychologist and counselor, and I am here breaking down the Karen Read case, because where else would I rather be? I think it was only a half day today in court, but this week has been a big fat F for the Commonwealth. I'm not so sure that things could be much worse. Now, I'm biased, so I'm not a juror. I have absolutely no idea what's going on in the minds of the jury, but in my mind, all that the Commonwealth has done this week is provide very clear and concrete evidence that the police in this case planted evidence. That is what they have done. And today was no different. I have to tell you about how my day started, because actually, when I first went to make this video, it wasn't going to be about what was going on today at all. It was going to be what went on in the 24 hours before today. Take a look. I am not a social media girl. Yes, obviously, I'm a YouTube person, but you're not going to find me posting frequently on Instagram or X or any of the other social media apps. So for me to even open Twitter or X and look at anything is a big deal. Now, I wouldn't have even done it today if it wasn't for the fact that I had opposite side of the street parking day. And so I'm sitting in my car looking at my phone. And I'm thinking, I wonder if anything is going on that I missed on X with the Karen Read case. So I open up Twitter, and this was the first thing I see.
Commonwealth, prove your case beyond a reasonable doubt. Prove that that person is guilty of a crime. Then we put on our defense, and our experts respond to yours. Then rebuttal is limited if you want to respond, but you can't just call your expert for a whole other set of expertise and testimony on the new information, new testing, things like that. If you do, she should absolutely let ARCA come back and respond again. But that's just not how it's done. The Commonwealth is supposed to prove their case in their case in chief. That, to me, if Judge Canoni allows it, would be a major appellate issue.
I turned my back for one evening, one night, a few hours. And this is what I wake up to. So now my head is popping off because I did watch the entire trial yesterday, but I turned it off as soon as cross-examination ended. So I didn't see the hearing that happened after. I didn't even know about it because normally I would watch recaps, but because I was turning my attention to P. Diddy, I didn't see any of the recap. Then, as I am looking at my Twitter feed, My sister texts me, no more buffer zone. So now I'm searching through X to see what that's all about. Is that true? And what happened? So I find this document, and at first I'm not sure how to take it because I read the document and it says you can't wear certain clothing or make certain statements, anything that could bias the jury. But then you scroll a little more and I see this. So we won. Yay. We get our little grass area back across from the courthouse, which is super exciting. That's really exciting. I was there last week. No, that was this week. I was there on Monday and saw how the whole setup was. And I'm excited to be able to go back now and support Karen Reed on the lawn across from the courthouse. So that's on a big win, a big, big win. But now I'm scrolling more because now I want to find out what happened in this hearing, right? What was this all about? And this is where my head literally almost explodes, where I feel myself like leaving my body, absolutely freaking out.
The relevance of this issue has been clear throughout the case, including my opening statement. And the issue is that clocks are different. There is a clock in a Lexus that runs on a different time than that of an iPhone. And if you recall in my opening statement, I talked about the fact that there are variances between those clocks. So instead of a moment that coincides happening at the precise second, sometimes there's a variance of time between the two. So the Lexus clock could be at a variance with an iPhone, but the event still could happen at the same time given the clocks have different times.
Hello, everyone. Hank Brennan wants to change his timeline just as he's about to wrap up his case. Just as the prosecution is about to wrap up their case, Hank Brennan wants to change the time of the incident, the time that John O'Keefe was killed according to the Commonwealth.
Respectfully, Your Honor, the defense is very confused. They attempt to confuse the issue. They attempt to confuse Your Honor about what the impact would be. This has never been a change. The government is not changing their timeline. The Commonwealth is not changing any information. The Commonwealth is not offering anything that affects in any way the testimony of witnesses. It's notable in the argument there is no relationship to the facts or the actual report that was provided. The Commonwealth has always provided the data, which they have, and they hadn't a chance to analyze. And the interpretation of the data has been different between the parties. We have been clear from the beginning at the time in which the infotainment system shows that there was a collision. We've been clear. And the data has been clear. That has never changed. That data in the telestream system is based on a clock in the Lexus, which both sides know full well is different than a clock in an iPhone. You can see all the productions of Dr. Welcher's PowerPoint presentation where it shows that time, 12/31/43, has never changed. Also, it has been clear that both sides appreciate that there is a variance between the clock in the Lexus, which leads to that system information, and a clock in an iPhone. In fact, the defense was so aware of it, they hired an expert, Mr. DeSorga, who gave his opinions about that variance. We have never suggested there was not a variance in this case. In fact, we have highlighted the variance. When their expert, Mr. DeSorga, provided a report, we believed that his analysis was wrong. And so we looked at the variance and the data that was available from the telestream system and John O'Keefe's Waze data that was on his phone that was always available to all of the experts in both sides. And when Mr. Burgess looked at the variance at the time of a three-point turn about 7 minutes before the collision, he simply matched the Waze information on Mr. O'Keefe's phone to that of the information from the telestream and saw that it was a 21 to 29 second variance. All that data was available to the defense because their expert made an improper conclusion is not our fault. This does not change the testimony of anybody. They point to Jen McCabe's text message where she said she thought she saw a motor vehicle out front that evening at 12:45. That is not consistent with the Commonwealth's timeline, but that doesn't change. That favors the defense. It does not change anything to do with ARCA. ARCA has not, as far as I've seen in any reports, ever talked about the variance, just Mr. DeSorda. And so because this is inconvenient for the defense, and because it further focuses the variance that we already discussed and provided, isn't a reason to exclude it. It's not late discovery. It's not a Rule 14 violation. It is further analysis of information that was already provided, opinions that were already provided, and it is in response to their experts' mistake about that variance. There's nothing new here. Nothing has changed.
Do you think Hank Brennan ever?
Go right ahead, Mr. Leslie. The only question I had for you yesterday, for you to respond to today, was the time. So I gave you more leeway.
And you're giving me more leeway, and I appreciate it.
Go right ahead.
So, two items, Your Honor. As I alluded to yesterday, and it's been a point that Mr. Brennan just made, we believe strongly, Your Honor, that at a minimum there needs to be a voir dire of Mr. Burgess. And we believe strongly there needs to be a voir dire because we have a serious concern that the sequestration order has been violated. He has changed a very key aspect of this matter after the testimony of Mr. Whiffen, after Mr. Whiffen presenting a timeline. In his report, Mr. Burgess, his new purported report of May 8th, he references to align it with Mr. O'Keefe's cell phone. That is the essence of Mr. Whiffen's report, is anchoring in his timeline. He did a whole timeline on Mr. O'Keefe's report. And conveniently, the proposed alteration by Mr. Burgess in his report of this clock drift now makes it very, very close to fitting within Mr. Whiffen's timeline and the theory of the prosecution. At a minimum, we need a voir dire to ask Mr. Burgess, why did he do what he did? Another reason for the voir dire. Mr. Brennan yesterday said, we were surprised to get the report. That further makes great concern as to why Mr. Burgess did what he did. Lastly, Your Honor, with regard to Mr. Brennan's point, and he made it yesterday and I corrected it, he said it again today, that supposedly our witness, Mr. DeSogra, made an error and that we're trying to correct an error of Mr. DeSogra. That is incorrect, Your Honor. Again, Mr. DeSogra was responding to Mr. Burgess's report. Mr. DeSogra's report is entirely saying, okay, Mr. Burgess says this, and therefore the defense says this. Now Mr. Burgess is changing what he is saying. So it is completely incorrect to say that Mr. DeSogra is trying to correct an error. That would require, again, Mr. DeSogra to change what he has done. Final point is this. There was also an issue, Your Honor, and this is extremely important with regard to burden shifting. There's not only the question of should this be allowed at all, there's not only the question of how much time the defense will need, but there's a third and important issue, and that's burden shifting. What Mr. Brennan proposed yesterday was a very irregular process where essentially the Commonwealth gets 3 bites at the apple for a problem that they caused. The problem we're talking about is Mr. Burgess changing a significant part of a timeline. Yes, there was a variance that he had, but he picked a range of the variance. He's now changing the variance. So what the Commonwealth is proposing is that our witnesses go forward, the aperture gets to wait, they come on, and then the aperture gets to come on yet again. We would urge
I did not understand the Commonwealth asking me that. Are you asking me to do that, Mr. Brennan?
I appreciate the clarification.
I'm not sure what he's saying, so...
It sounds like DeBrosia or whatever.
His name is DeSoder, yes.
DeSoder, You're suggesting that the Commonwealth suggested yesterday that he testifies first and then the Aperture witnesses?
What I understood was going to happen is Mr. Brennan said yesterday that Dr. Welcher cannot come in until after.
No, I didn't understand that. I understood Dr. Welcher, Shannon Burgess, and then Dr. Welcher for everything that you folks received prior, January 31st or whatever the date was. And then potentially for all the new ARCA information that came in May 7th, that portion, Dr. Welcher returning on rebuttal for. Not that they were holding back Dr. Welcher completely. Is that correct, Mr. Brennan?
That's the conversation I had. That conversation I wasn't part of.
Yeah, I think you misunderstood that, Mr. Alessi.
So just so I'm clear, what is it that the rebuttal?
Mr. Brennan, all right, this is separate, and I'd really like to give everybody a break here. What is it the Commonwealth is asking to do regarding that?
Regarding Mr. Burgess or Mr. Welcher?
Dr. Welcher.
Dr. Welcher should come in and testify to his PowerPoint, all of his opinions, which address all of the prior representations and opinions of ARCA, although we still don't have any raw information, but we're ready to move forward. Regarding any new opinions, which there is over a dozen new opinions that includes testing, video, experiments, Dr. Welcher should have enough time to review, conduct his own testing, turn it over, and then in rebuttal address limited to the new issues raised by ARCA.
That's how I understood it, Mr. Alessi.
And that's how I did also, but the question is now with the Burgess changing of the clock drift, how many times is the Commonwealth proposing that Dr. Welcher gets to come in and talk about that? Is he just going to come in and talk about it?
So you talk with Mr. Brennan about that. All right, so I'm all set for this.
There are no changes. There is no changes in the timeline. He keeps trying to portray this as something has changed. Nothing has changed. It's the exact same. He's always said there's a variance. He's been looking into the variance for a long time, and now he has found a method to show the exact variance. It's not changing. There's nothing in the reports that changes as far as the timeline. That's just an attempt to cause fear. There's nothing that has changed. We can look at the reports. It's all the same, always has been, other than now he's identified the mistake of their expert, and that led him to be able to identify the variance, which is helpful and new. And the suggestion that there's been some violation of an order, no good faith basis whatsoever.
Does the Commonwealth oppose a voir dire just on that one issue?
Yes, because it's suggesting that there's a good faith basis for it. Nothing has changed. Ian Whiffin's report was available to the defense and our experts months and months and months ago. The issue of variance has been an ongoing issue for months. There's nothing that triggers a change in the testimony to adopt or adapt to it. Our timeline has been the same since when we turned it over at the beginning. They cannot point to one thing that has changed between Dr. Welcher, Ian Whiffin, Jessica Hyde, or Shannon Burgess. They are just saying things without a good faith basis. In the reports, show us where something has changed.
Your Honor, to inform you, Your Honor, we would like to print the page in the clock adjustment because what Mr. Brennan says is
yes,
correct.
and I'm happy to any information.
Thank you.
All right.
Change.
20 minutes.
Now, this would be what, the 8th time that they've changed this time of the incident, which didn't happen at all. So it's absurd to begin with. Of course, you can't figure out what time it happened because it never happened. You see, the problem with Hank Brennan is he thinks he's the defense attorney. He thinks, well, no. The defense has their theory of the case, and my job is just keep refuting it. But that's not the case, Hank. Hello, you're supposed to be the good guy. Somebody tell this guy, please. I can't. The thing that's the most infuriating about this is you know that the judge is not going to do the right thing. She's absolutely going to let this piece of garbage do whatever he wants, the weasel of the world do whatever he wants to do. Well, because it's fair, because she led ARCA. So, of course, she has to be fair. Right. Oh, yeah, fair. This is fair for sure. So apparently, Hank gets an email from Aperture his accident reconstructionists back on May 8th. And this guy says, oh, yeah, by the way, we have to change our time of the incident because we saw that Ian Whiffen's information is different than ours. And we just wanted to, change it so that it aligns with what Ian Whiffen is saying. We have built our entire defense around this time, the ridiculous time that you already gave us, which so clearly was incorrect, which the jury already knows was incorrect. And now, halfway through the trial, you want to change the time of the incident? Don't you think that's a pretty important point, Hank? And so the judge asks Alessi at the end of this hearing to come up with a solution. And he's like, no, the solution is absolutely not. He should not be allowed to change the time. And of course, is she going to allow him to do it? Absolutely she is. Of course she is. She's got to be fair. Can somebody in Judge Bev's inner circle explain what the definition of fair is, please? If I'm the judge on this case, and thank God I'm not, okay? Just thank God. Because this moment, right now, listening to Hank make this argument, I would look at him and say, it is time to pull the plug on these charges, dear, because you can't even figure out what time this happened at. And you've changed it like 8 times. You're trying to make this argument that this woman killed a man and you can't even figure it out. You don't even know when that happened. You don't know if it happened. You don't know when it happened. All of your witnesses so far are basically saying, yes, probably the evidence was planted and now you want to change it. About to wrap up your testimony, about to wrap up your case. Now you want to change it. What is she going to do? Of course, she's going to grant it. And well, I expect a rigorous defense from you, Mr. Alessi. Oh, yeah. And just one more thing. The Commonwealth is agreeing with the defense's cell phone expert that the clocks that they have been using to evaluate John's death are wrong. So here is Mr. Richard Green explaining precisely what the situation was with John's cell phone data and the clock.
Sure. Well, app developers can access Apple program library, and they can call upon any of the clocks to use within their apps.
What does that mean that we're in right now?
Yeah, well, this is an artifact specifically related to the Waze program.
Waze app.
Yes, sir.
All right. Go on.
Okay, and we can see here our entry for the monotonic time, the baseband time, and the display time.
And what did you notice about the relationship of the 3 of those?
Certainly. Well, most noticeable about this, the monotonic is running a little over 3 minutes ahead of the display. So that, I think it's 3 minutes and 1 second, give or take a little. So, in a lot of cases, 3 minutes may not seem like much, but in this case, this struck me as important to.
Objection. Move to strike.
Sustained. I'm willing to strike that. Next question.
Okay. I apologize.
That's okay.
So I continue to scroll down and I stumble upon this statement that the judge read to the jury.
I have one other important instruction for you folks, and it's so important that each and every juror can hear the evidence or the testimony that's presented, can follow the testimony, and can understand and evaluate the testimony of each witness and the exhibits. In order to do that, I just want to be very clear that it's important that people do not comment on the evidence or make any comments. Once you enter the room, it's probably a good idea to just listen. Don't talk. Don't make any facial expressions, no muttering under your breath, no audible noises, because people need to hear what's going on and to understand everything. So out of respect for your fellow jurors, I would ask that you be very careful to make sure you don't do that, and out of respect to the lawyers who worked so hard to get this case before. Okay? Thank you very much. With that, Mr. Brennan, your first witness, please.
Now, some people on Twitter were trying to insinuate that that was likely the Commonwealth's asking, that the Commonwealth were the ones that wanted to give the jury that instruction. But actually, I think that's one of the smartest things that the defense could have done, because we know that at the end of the last trial, what did the Commonwealth do? What did the DA do? Talk about playing dirty. They conveniently removed, right before jury deliberation, one of the jurors who was the most viscerally affected by Michael Proctor's text messages, the person who was the most clearly on the side of the defense. Oh, suddenly it turned out that one of the Massachusetts state troopers turns out to also be in charge of the jury somehow, who heard from somebody who heard from somebody who heard from somebody that this juror was talking about the case in a bar. So she was conveniently left out of the deliberation and asked to be excused. Not only that, the other jurors whose expressions seemed to indicate that they were pro-defense, they just weren't picked to be a part of the jury. A selection process that was allegedly random, like pulling out of a hat. Right. So it is critical that nobody on this jury blinks an eye. Do not make any indication whatsoever that you are pro-defense, because the Commonwealth will just keep you off of the jury. They'll just kick you out at the last minute. So don't get too comfortable, because that's how corrupt these people really are. If the Commonwealth has proved anything, if they've proved anything so far, it's that there was absolutely an effort to plant evidence. I have never been so sure. And they've kind of given us a roadmap as to who did it, when they did it, and how they did it. So thank you, Hank Brennan. That was so helpful. The only way that you see the evidence that he's presented as evidence of Karen Reed's guilt is if you start out wholeheartedly believing that that is true. If you believe that is true, then your brain will, as it is trained to do, carefully select the information that you attend to support that idea, to support your already pre-existing belief, just like the rest of the district attorney's office have already done. But I think it's pretty clear that the defense is pointing the finger not at Proctor and Buchanan. No. But at Lieutenant Brian Tully and the chief of the Canton Police Department at the time, Kenneth Berkowitz. And not only that, for the first time, and maybe this happened during the last trial, maybe I wasn't paying as close attention to it as I am now, but for the first time, we heard insinuation today from Yannetti when he was cross-examining the DNA witness that Kevin Albert was also somebody on their suspect list. Now, I'm still working on my theory of the case video, and his name, hint, hint, might come up in that video. Oh, and one more thing. Back in November of 2024, Lieutenant Tully was removed from the district attorney's office of Norfolk County. Apparently, because of the internal affairs investigation, they decided, maybe you shouldn't be in this office anymore. But you'll notice Brian Tully hasn't been taken off the Karen Reed case because he's been right by Hank Brennan's side, preparing each and every witness for the case for the Commonwealth. And don't worry, he's still doing everything he can to try to put Turtle Boy in jail. So thank you, Lieutenant Brian Tully, for your service. But I think it's worth noting that somebody somewhere thought, maybe you shouldn't be in the DA's office anymore. And all of that happened sometime within the last 24 hours while even though I watched all of the witnesses yesterday, that I only turned my attention away from the hours of 5 p.m. to midnight so that I could, have dinner, have a child, have a life, and yes, turn my attention to P. Diddy and what was going on in that case. So, lesson learned, that is what happened when you blink when it comes to the Karen Read case.
God save the Commonwealth of Massachusetts.
I live inside my own world of make-believe. Kids screaming in the cradles, profanities. I see the world through eyes covered in ink and bleach. Cross out the ones who heard my cries and watched me weep. I love everything.
No words.